as well.
Just the other point I would raise on privilege, and this is a little further down the line, but is when you're talking to the government. And that, it's, typically that comes more towards the end, but in a DOJ context, I've had it come up where, pretty early on, a few months into the investigation, you may realize or may come to the conclusion that there's no criminal intent, and you may decide to make an early presentation to the DOJ or as part of cooperation. The important thing here is there is going to be follow-on civil litigation, as already been mentioned. Those slide decks you share with the DOJ or the SEC are not going to be privileged, and any plaintiff's class action lawyer is going to request any material shared with the U.S. government. So you have to be careful about what you say in those and thoughtful. I think it's helpful, whereas in a brief, if you're actually in court, if you say the government has alleged X and Y, we didn't do X and Y. Like I would be careful, for example, about characterizing the government's allegations, because you don't want, a plaintiff's class action complaint, especially if the DOJ eventually moves away or moves off that theory, to say, the government thought, as evidenced by the company's own slide deck, the DOJ thought that the CEO was this and that. So you have to be very careful. You just have to assume that those materials you share with the government are going to end up in the hands